In relation to more particularly, I think, medicinal cannabis, it's worth remembering that whilst it was once illegal in its entirety, it's now benefiting tens of thousands, in fact many more Australians than I would have predicted 5 years ago. When it comes to workplace drug testing, one of the challenges in a fast-moving environment in relation to these issues is that some of our legislative frameworks are not contemporary and appropriate for current circumstances. And I think there's a very cogent argument to make amendments to the Equal Opportunity Act to protect people who are being prescribed medical substances. Fundamentally, we've got a situation now where we have people who are prescribed medication and are at risk of losing their employment, are at risk of absolute destruction of their livelihood because they are putting their health and the advice and recommendations of their doctor first. They're therefore discriminated against in the workplace because, I think, mostly of the hangover that we have from when cannabis was purely illicit and the medicinal benefits were not understood.
While traditional sources of law have provided some normative framework for workplace drug testing practice, they are insufficient to ensure that workplace drug testing practice respects employee privacy while achieving legitimate goals. In our submission, we highlighted the importance of considering the relationship between drug testing and stigma and discrimination, including because various state, national and international strategies and guidelines now emphasise the need to eradicate drug-related stigma and discrimination. What we're talking about in our submission is the need for an overarching, consistent framework with consistent principles and practices and sort of and fundamental principles about how workplace drug testing should be approached.